I would be given the same protection as anyone,
as the other
whether it
party.
be.
And it doesn't matter if it's the other party in your case, any, like you said, anyone, any other party associated with the matter. You have a
Yeah.
due process right and an equal protection right to be treated fairly, honestly, without bias and without prejudice. So, and
Okay.
if Johnny in Timbuktu was given this opportunity and given this right to have his case vacated, and if this court, and this is what I like to say, if this court has ever vacated a judgment because the court failed to give notice, then it must do so in this instance as well, for it would be a violation of due process and equal protection of law. That's how due process and equal protection of law go hand in hand. They always go together. They're never separate. So if they violated your
Cool.
due
Okay.
process right, they violated equal protection of law. It's called the due process clause of the Constitution and the equal protection clause of the Constitution. If you look it up, you're going to be given a lot of legalese. Okay, and it's going to be ambiguous. It's going to say all kind of junk to where it's not going to be clear. So basically, due process simply means that if they have a procedure, if they have a policy, then you have a right to be treated in accordance with that procedure and that policy. And they cannot deviate from that procedure and policy in order to violate your rights. You have a right to due process for them to follow the process, okay? You are due that right. Then as far as equal protection, if there is a rule, if there is a law, and you fall under that law, it doesn't matter whether the judge thinks you fall under that law or not. It's whether or not you fall under that law and the protections of that law. It doesn't matter if it was a woman who was given that law's protection. Doesn't matter if it was a dog who was given that law's protection. Do you remember the case? It was called Swift Voters. The Swift Voters.
No, I don't remember that.
It was a case law, and these were individuals during the Bush, when Bush was thrown into office, and they were having the votes recounted. When these idiots didn't realize that the popular vote never counts in presidential election, but they were trying to get the votes recounted in Ohio and in Florida. Well, the Supreme Court.
I remember that.
There was another case dealing with the same group, because they were trying to give money to certain campaigns. And so we had two cases that they brought before the Supreme Court, and the Supreme Court ruled in both cases that corporations are people too. You've heard people say corporations are persons too. Well,
yes.
we took that case law and we put it in our POA that's on the website. And that POA, that case law in there, the Supreme Court ruled that one of the cases is Hobby Lobby. They ruled that corporations are people. And because they are people, they have the same rights as any other United States citizen, because corporations are United States citizens. That's why people have been going into court and saying, hey, I'm not a corporation. Okay, but corporations are people too. They are U.S. citizens. Supreme Court has ruled this. Well, that being the case, if a corporation has the right to this or that or this, then you have the same rights to that, this, and this. It's called equal protection of law. Okay? These are your main points to bring up in every challenge you bring up in every single case. When you go on appeal, you always bring up violation of due process and equal protection. The woman, the woman who poured that chemical on the other woman's face in Florida, her name was Bond. And the case was Bond versus the U.S. Well, what she did is she went into the federal. Well, yeah, one of her good friends was having sex with her husband and was pregnant with her husband's child, and they worked in the same so-called chemical laboratory. And she took some of the chemicals from the laboratory, allegedly, even though the case is over, and she threw it in the face of the other woman. And the federal government, it was all over the news. From Florida to California to New York to Puerto Rico. It made the news. And the federal government decided that they were going to take on the case. And some stupid prosecutor for the federal government decided to charge the lady with terrorism, violation of international treaty, because she violated war crimes laws. And her attorneys didn't pick up on it. She was tried and convicted. And on appeal, somebody in jail helped this woman with this case. And the reason why I know it was somebody in jail, because an attorney would never have brought it up the way the person who brought up her appeal brought it up. That they had violated her state constitutional right and her federal constitutional rights when it comes to the 10th Amendment. And the 10th Amendment says that you have certain rights and protection. The 9th Amendment says you have certain rights and protection. Put in there that the court violated your 9th and 10th Amendment rights. Then go back and look at the 10th Amendment and notice how the 10th Amendment says that the 9th Amendment says you have retained rights, and the 10th Amendment says you have reserved rights. Well, those reserved rights, it's not spelled out. But I assure you, those reserved rights refer to due process, equal protection of law, inalienable and alienable rights. Only people like me, us so-called old schools, will bring up arguments like this. Why are you bringing this up? Because you put it before the appeals court. The appeals court are the more learned. The word that judges use for themselves and lawyers use for themselves is learned, like they're of the learned. Well, that's where the more learned individuals are. The Supreme Court are the where more learned people are. And then, of course, the federal courts and the Federal Court of Appeals and the United States Supreme Court, that's where you have your more experienced, more educated people. Well, what's happening is when you appeal, you get to bring up all of the stuff you're bringing up now that you didn't bring up previously prior to all of this. So what I'm trying to tell you, by doing a motion for reconsideration and a motion to vacate, even though the case is over a year ago, you now get to introduce new evidence into the case, which you would not be allowed to do because the rules prohibit it. So I am giving you an in and around, a technique, a strategy that attorneys don't even use. That's why when you contacted the attorney, they didn't tell you this, but you spent $1,500. Thus far, you spent $2,000. Okay? But I promise you, you really won't need help on the appeal, other than the fact you just need to go over what the rules of the appeals are for that court and get a basic sample appeal. You want a sample successful appeal, and you put the name of the court. So in Google, successful appeal, United States, or successful appeal, the court of Clark County, blah, 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 PDF. In Google, with a question mark. And then you look for an appeal from that court that was successful. You can even go down to the court and tell them you need to see and get a list of the appeals that have been heard by the court, where the court has remanded it. Pay attention to this word, where the court has remanded it back to the state court, where they sent it back to the state court. If it was remanded, that means the person won the appeal. You don't want an appeal that was dismissed. You want an appeal that was remanded, because you want to use the arguments in that remand in your appeal. And you got plenty of time to do this, because right now you're just doing a motion for reconsideration and a motion for vacating of judgment. When you put in your motion for reconsideration, and you've already been introduced into the case, so you don't have to worry about that. In the future, somebody comes at you with a lawsuit. I don't care if it's a lawsuit for 5 pennies. You do a countersuit. You don't just let somebody sue you, because as long as you don't do a countersuit, you remain in a position of, a defendant. So you're in a position of catching up, as opposed to a place of being in front and throwing punches. You know, when you let somebody sue you, you're taking punches. But when you countersue, you are countering every punch, and you are landing punches. That's what you want to do when you file your countersuit. Okay?
Okay.
All right.
I understand that now.
All right. Now that's the best that I can do you. On our website, I just put up it's under court forms templates. You'll find sample motion pleading forms on there, so you don't have to go searching all over the internet for all of this. You won't find summonses. I haven't put that up there yet, or subpoenas or anything like that. But for the simple fact you're only filing a motion, you'll find the samples. You don't have to physically go down to the court, but I'm saying go down to the court, bring 3 copies with you. Give one to the stupid clerk, and I say stupid clerk because they don't have too much sense. They keep trying to tell people what they can and cannot do when they know by law they don't have the right to refuse a filing. Only the judge can refuse a filing. But
And by the way, the Clark County Court is 5.5 hours away. So I'm filing in Kenosha County, right? We're suing from Kenosha County.
No. This right here, no. That's your countersuit. That's your suit that you're about to bring. You're going to do that in Kenosha.
Okay.
But in Clark County, you're just going to mail that to the court. Send it in 2 separate envelopes. So you got send them 2 copies. And I'm sorry, but you have to do this. In both envelopes, include a self-addressed stamp copy envelope. And do only put 1 stamp on it. Do not put more than 1 stamp. Okay, if it's extra postage, let them pay for it, because what they like to do is they like to send you all your paperwork back. So let them pay for it. But this is so you get a filed stamp copy back.
I understand.
Okay? All right, now that takes care of that for you right now. And I promise you, I've given you more than enough to just get that thing, because it's not really you're trying to win anything. But do it as if you're trying to win. Do it as if you're trying to get that case restarted, because that stops anybody attempting to garnish your wages. That stops you from having to pay $300 a month. Okay?
Okay.
So do
and
it
that
as,
stops it after if they deny the...
If they deny it, then everything else goes on the way it was going. But if they deny it, then you immediately file what's called a notice of appeal. All a notice of appeal is a document, just like you're putting motion for reconsideration. Instead of putting motion for reconsideration, you say notice of appeal, and all of that junk you had in the body, you just copy it to another page and get rid of everything in the body of that form, and you just put notice of appeal, put your signature, the date, and that's it. Notice of appeal, all it has to say in the body is notice of appeal. It doesn't have to say anything else.
Okay.
A lot of people... Sometimes I do it too. Sometimes in order just to piss them off, in order to add information that I can do on appeal, I'll add all the information in my notice of appeal. I'll say everything that the court did wrong, and I will put that in my notice of appeal, and I'll send that to the court, because you can't introduce any new information on appeal. But I can do it in my notice of appeal. So that's another technicality that I use when I'm dealing with the court. All right, but you simply write notice of appeal, you send that to the appeals court. The moment they deny any one of the motions, it doesn't matter if they denied one first and the other one second, the moment they deny any one of the motions, you do your notice of appeal. There's going to be an appeal fee, so do a fee waiver. Okay, remember,
fee waiver is done through the courts?
the fee waiver is done through the courts. So when you do your notice of appeal, I would attach a fee waiver. You can download it from the court's website. And the reason why you do a fee waiver, because you don't want to be paying those stupid fees on no appeal, when you know that they're going to sit up there and probably deny your appeal. But this right here, the appeal, is only to keep things going, and it's only to give you back that fighting chance that you lost. But in your case, I don't think you're going to lose your appeal.
Okay. Did you by any chance get a chance to look at what I sent?
I have not had a chance to look at it. What's happening is this morning, I have been working on that website all morning, and then the Kingdom Hall is this morning. So I've been on the tie line with the Kingdom Hall this morning.
Right.
So that ended at 11:45. That's why I had you call me at 12.
Right.
So
well,
it's been a long morning.
You'll have that, and then in there I included the judgment, actual judgment, and then.
Well, I do have it on my phone. I did download it to the phone. So while you're on the line, give me a second to get to that section of my phone. So I'll try to take a look at it while you're on the phone.
Oh, okay.
All right. Now let's talk about that. The other case that you have to file in that county. It is a simple filing. Remember, I've already told you want to ask for a jury trial, and when you ask for that jury trial, you want to ask for monetary damages. You want to ask for a jury trial. You want to definitely get them for conspiracy and violating your rights. Okay.
Okay.
Now, I take it, the first thing I'm looking at with the stamp on it, that's from Mr. Miller?
Yes.
Okay. I can tell by the... You know what? Did you ever file this?
No, that's what I'm waiting to file, because that's what he wrote up to go with the complaint of the lawsuit.
Okay, so this is for you to file your lawsuit.
Yes.
Okay, get
And
rid of...
he said he wrote it in such a manner that if it goes all the way to world court, quote unquote, it goes to federal court and all the way up to that, according to whatever that means.
Do yourself a favor. I understand what he means by if you took it and appealed it all the way past the Supreme Court of the United States and you took it to the World Court, which is at the so-called UN. I get that. Do me a favor.
Yes.
You're going to be filing this in Kenosha County, not Clark. Okay? That's the first thing.
That is correct. Yes.
Okay, so you're going to have to change that on the document. Attach it to your complaint and make this an affidavit.
Oh, okay.
Okay, don't make it just a document. Make it an actual affidavit. Okay, because I do see the Clark County stuff here. Oh, I'm sorry. I give David some credit. I can see what he's doing, and I like that. And he knows, like I know, the court will probably not pay attention to it. At least I know on the first level, the court won't pay attention to it. On the appeal level, the court probably will pay attention to it. But to give it some weight, add a jurat to it. Okay? And
And what to it?
a jurat. A notary jurat. The
Okay.
part that the notary fills out is called a jurat. Okay? And then
Okay.
do you see where he says for the Clark County Circuit Court in the Wisconsin State Territory?
Yes.
Okay. At the very top, put an affidavit to serve as evidence. Just that simple statement, an affidavit to serve as evidence. And after you put
Okay.
evidence, put the quotation mark that starts the beginning of a quote. And at the very end, at the last page, you put the end quotation mark. And then that's where the jurat and your signature and everything, you do that after that. Okay? Because you want it to be an affidavit. You want these to be your words. Technically, even though David wrote this, you want it to be your words.
Okay. So
Okay.
that's a separate sheet of paper that creates this, the draft you call it.
The jurat is, just go online and just type in jurat. Okay? And you'll see
Okay.
what a jurat
Okay,
is.
so-
That's the part.
D-U-R.
No.
Spell that.
J as in James.
Oh, J.
U-R-A-T. Jurat.
Okay, got it.
Sounding like jury. Jurat. Okay?
Okay.
All right.
Got
So you're going to add the jurat, make this an affidavit. Just like your motion, you're going to make it an affidavit. So even though it's a motion for reconsideration, after you start the motion off, you're going to do affidavit. As a matter of fact, did I send you a sample motion?
Not yet.
Okay, I don't know if I have anything handy that I've done where
We've
I've...
got time. We've got time. I'm gonna be researching.
No,
I'll be looking
what
at
I
it probably
what I
4 or
want
5
you to
times,
understand
you know.
is, as busy as I am, you say time. I promise you, if I don't have time now, it will never happen. I just can guarantee you, and I'm looking to see if I have a sample. You know what? I'll do you one better. In this lawsuit, in this the website, under when you go to satcom911.com and you go to downloads, under downloads, what you do is you go to under the very top. Those are the folders. There's one called Court Forms and Templates. You can't miss it. It's got I think 119 or something like documents in it, and you're just gonna type in defrauded. You can do the search, or you can go down to D. Defrauded Homeowners of America. That lawsuit at the beginning says affidavit. So you'll be able to get an idea of how I do the motions. There are some others in here that are done the same way, but I can't tell you where they are because I uploaded all of these documents yesterday and I just copied the whole site to my computer today. So it's been a lot of things going on. There are a lot of motions
Okay.
here that you can glean from, that you can get some information from. Okay? But
Okay.
I tell everybody, always make your motions affidavits. You definitely do that now because affidavits are evidence. And right now, you have no evidence on the record, and you must always, whatever evidence, it's not gonna be under D, it's gonna be under the defrauded homeowners. Okay, so it's all the way to the bottom, just about. Okay, but that's it in the beginning. That's how I did the motion. Understand, you're not following that format. That's federal court, and that is a multi-billion-dollar lawsuit. Okay, so that lawsuit is not the template you're following. I just want you to see the affidavit part at the front, how it's worded. An affidavit always must say that you have first-hand knowledge of that information.
Understand. Okay.
Okay, I do have another one. I'll try to get you the other one. That one we're not sharing with the public, but I'll try to get that one to you. Or I'll find another one on this computer that says affidavit. I should have several. Okay, so I'll get one of them to you. I'll do that before everything is said and done. Okay.
Okay.
But yes, I don't want you to wait too long before you file your suit. Okay, and I don't
Yeah, I
want
want
you.
to do it next week, actually.
Yeah, and I don't want you to study too hard on any of this. The idea is if you go back over our last call and go over this call, that's the information you want to be bringing in your suit. You don't have to be detailed. You just have to give a brief summary of all the things that took place. And it must say, this is the reason why I need to send you a copy so you'll see. It must say that you are stating a claim. Okay?
Okay.
If you don't, they'll say that your matter is being dismissed for failure to state a claim. I promise you, this is their routine. It took us years to realize what they were saying is that we needed to say we're stating a claim. They were getting technical with us. And the Supreme Court was allowing them to do this, allowing them to play these little stupid games. This is how the game is played. This is how the game is played. Okay? Are there any other questions from you, sir?
I think I got enough to kind of get me started in this direction, and I'm pretty good about it at this point. I'll keep moving forward. I did have some other questions regarding the financial matter stuff, but I can hold off.
You can ask.
On that.
You might as well ask.
Okay. Well, regarding the 1099 and the A4B.
Oh, the one that I sent you?
Right. Is that? Did I understand you correctly? That I did not have to do a UCC one filing, like any type of.
Here's the thing. None of you ever had to do a UCC on anything. The ones who've been telling you gotta follow UCC, none of those individuals have ever accomplished anything. You don't have to follow UCC. It is not required that you follow UCC. A UCC is only filed to document a security interest. It says it right there in the rules what the UCCs are for. It's a lien.
Okay.
That's all a UCC amounts to, is you're documenting a security interest in something. Now, should you follow UCC? I don't know. I mean, you're just getting rid of debt. Okay? Oh, by the way, if the IRS ever sends you a letter saying frivolous filing or blah, 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 that you did this, then you shouldn't have did this, then you send them back the same forms that you did originally. This is a new copy, and at the top, you put corrected or void, and you send it back to them. Once you void out the original document you sent, you get no more frivolous filings and no more threats of charging you $5,000. Okay? That's how you take care of the IRS when they're coming at you saying that you filed a frivolous filing. You either do a corrected filing, which starts that process all over again, or you do a void. Because it tells you right at the top of the document, if you look at those documents I sent you, it says void or corrected at the top. That's what that's for.
Okay.
Okay, they came up with a law because all these people are watching these videos and they're sending all this junk in and getting in trouble.
Now, I understand that there's only one or three, maybe three specific locations that you would send these A for V's to.
No, don't call it an A for V. Don't put A for V anywhere on it. Even the stamp, don't mention A for V accepted for value anywhere on the stamp. Get rid of that language and just keep the rest of the language of the stamp. But Ogden, Utah, or you can send it directly to the address. People are misunderstanding this. Send it directly to the address where the forms are supposed to go. The website tells you, or the 2017 general instructions for 1099s will tell you the address where you're to send things. And you just send it directly to that address. Ogden, Utah flags people's documents and they don't know this. And they keep sending it to Ogden. Now look, I want to make sure of something. I want to let you know what I'm doing right now. Because the information I was talking about, a lot of people have been sending me emails thanking me for putting the legal stuff up on the internet. I want to put this on there, but I need your permission. We haven't mentioned your name, okay? I've only mentioned Clark and the other county, but we haven't mentioned your name. So I want to make sure, I'm asking you if it's okay for me to do this so I need them to be able to hear the other person's response so that they can see the conversation. Because normally when I'm doing the information, I leave out a lot of stuff because I can't anticipate a person asking certain questions because I can't think like you guys. Because I already know this information.
Yeah, you have my permission. Yeah.
Okay, I have to ask because I can't just do it. That's my conscience won't let me. So I needed to ask. But you see how you're coming from a standpoint of you don't know this stuff. But see, when I'm explaining it on video, I can't think as if I don't know the stuff, because if I don't know the stuff, I'm going to think about the basic stuff a person doesn't know. I'm not going to think about the techniques that you can do to get around the stupidity of the judges. Remember,
that makes sense. I understand.
You went to an attorney, and the attorney told you, no, you can't do anything now. Your time for appeal is over. And I just gave you, and you can't mention that this is what you're doing to get an appeal. Of course, I know you're not going to do it, but you have no idea how many people out there will do something like that and shoot themselves in the foot. This is how you do an appeal on a matter that's already been closed, because there's no such thing as a final judgment in an administrative court. You can always go back in. Okay?
Wow. That's very creative way of using, or I don't know if the word manipulating, but using the system.
It's manipulating.
For that. Yeah.
Nobody taught that to me. I had to figure that out on my own when I was probably 22, 23 years old, because they kept dismissing things and I kept getting irritated by it. Why are you dismissing this? I'm putting everything in here, documenting the fact they violated my rights, and if I go before a jury, the jury's going to rule in my favor. And they kept dismissing things. And then I would hear attorneys, because I'd go to an attorney because I figured, okay, I'll go get an attorney to handle this. And the attorneys would tell me the same thing they told you. Well, you're beyond the date, so there's nothing I can do. No, I'm sorry, I can't help you. And there's no other attorney who's going to take the case because there's nothing they can do. And so I said to myself, I was going through the rules, and I remembered reading the junk about reconsideration. And I'm thinking to myself, wait a minute, if I'm asking the judge for reconsideration, he makes a determination? Wait a minute. Then I'll just appeal his determination on my reconsideration. And that's how I started getting my cases and my appeals being done, and the cases sent back to the court and my cases won, is by simply doing a notice of reconsideration and going right back into the same court. The judge will be stupid and deny you, but the moment he denies you, now you have avenue 14 days from that denial to do an appeal. And of course, the judges won't appreciate this. That's why you're doing a motion to vacate and a motion for reconsideration. But you have grounds for your motion to vacate and motion for reconsideration because they had a hearing and you weren't present. And they did not give you notice. They did not give you notice. Okay. Anything else, sir?
Well, that would be all. I'm going to I'm trying to decide. I want to this week maybe go ahead and try to apply for one of those
I'm gonna
credit card